A lawsuit alleging the NCAA failed to protect a former USC football player from repetitive head trauma is nearing trial in a Los Angeles court. There's a jury that's seated. This could be a landmark case. This is about Matthew G's widow. She said the former linebacker died in 2018 from permanent brain damage caused by countless blows to the head. Now, what's interesting is some of the former teammates talked about some of the five. G is one of five linebackers, by the way, from the 1989 Trojan squad who died before turning 50. And Mike Salmon, who played defense at USC, went on to the NFL, 49ers, and Bills, said he distinctly recalled G and other linebackers being out of it during hard-hitting practices. So there's some interesting evidence here. Rob Crain is with us, a legal expert with Rob, what is the law firm?
Crain Brogdon.
All right. I want to make sure we give you a little plug there. I appreciate you coming on this morning. Does this case have any chance of going through the motions of a trial, or do you think the NCAA will settle out of court?
Well, I believe opening statements occurred late last week. I believe they're underway. So it looks like thus far they're going forward.
Do they risk opening the floodgates in case a jury comes back with a verdict against them?
Definitely. There are hundreds of lawsuits on file now. This case, as with most cases that have multiples behind it, the defense doesn't want their best case going in front of a jury to kind of start an avalanche of potential bad results. So there's no doubt that the NCAA is pegging this case to be a case that goes to trial early on because they've got some defenses in this one. So, yes, if they lose this one, it's likely that they will have a lot of poor results in other cases later.
I had my son tested for CTE and that kind of stuff. He played football here in Fort Worth, TCU, and he didn't have one, but had several surgeries. And the reason I bring this up is beginning in high school, why don't they just put out a release form that says you could get yourself hurt really bad or die playing this sport, sign here?
That assumption of the risk is a concept in the law, which is going to be discussed in this case out in California. And you're absolutely right. As we advance in our understanding of CTE, which, was discovered in 2002, and Mr. G played football in 1990 for USC, that's one of the issues out there is, could he have assumed the risk in 1990 of CTE? The NCAA says, well, that's the whole point. We didn't know back in 1990 about CTE. But to your point, yes, as we become more knowledgeable about these head traumas and their effects, you can have releases, and states like the state of Texas allows those releases to be valid and to prevent lawsuits later.
Talking about a possible case of the NCAA taking liability for somebody who has CTE. This is Matthew G's story. After graduating in 1992, got cut by the Los Angeles Raiders in training camp, married his high school sweetheart. 20 years, he lived a relatively normal life, the suit says. But that began to change around 2013 when he began to lose control of his emotions. He became angry, confused, depressed, drank heavily, told a doctor days would go by without him being able to recall what happened, and died ultimately. Cause of death was toxic effects of alcohol and cocaine, along with cardiovascular disease, cirrhosis, and obesity. Died on New Year's Eve 2018. The claim is that CTE is what killed him, that concussions and...
Well, if he did all that, that's going to be a tough sell.
Yeah, is that why they're letting this case go forward? Although that does seem to be a symptom, Rob, that these guys, they try to medicate themselves because of the pain that they feel.
Yeah, absolutely. As we talked about, the state of the art of the science is one of the reasons why the NCAA is going to defend this case. The other is the cause of death, but that is murky. Because CTE, as we have seen in other victims of CTE, they fall into the traps of any brain injury, any chronic pain situation of alcohol and drugs. So I don't know how much of a defense that is going to be, and I think the defense, the NCAA, better be careful with how much they jump on his behavior when we do know post-autopsy, post-study of his brain that he did have CTE.
Retroactive lawsuits, I guess it would be interesting to watch this particular case, because what about all the players that played way before that who they didn't get CTE, they just got their bell rung and the coaches sent them right back in. He hit his head. That's what they used to call it in my generation. So does this lead the way for retroactive lawsuits?
Well, you bring up a good point. Look, I played ball until '87, and I had my bell rung more than once. But CTE wasn't really understood, wasn't even known until it was discovered at Boston University Center back in 2002. So it'll be, from a litigation standpoint, I'm a plaintiff's lawyer. It would be difficult for me to bring a suit from a player in the 1950s or later. Yeah. If I don't have that diagnosis of CTE, and you're not likely to get it at this point in time. Yeah. Interestingly, though, this is the second CTE case to go to trial, and the first trial was in Texas and involved a University of Texas player who played in the 1960s. Now, that case settled shortly after trial, but to your point, it's interesting, though, that was the first CTE case to get to a jury or get to the trial process.
Wow. All right.
Rob, we'll have to talk to you again. There's so much more. There's a big field to go through. So this is Rob Crain with Crain Brogdon. Thank you so much for coming on.
Anytime.